Welcome to the Draper workshop series on history and the law. And it gives me great pleasure to welcome you and our audience here in the virtual world, beyond, as well as our speakers to the second Draper workshop. You know, I'm confident that the talks today and in the discussion following, we will not only be able to appreciate the value of combining interdisciplinary perspectives emerging both from the study of law and history, but also more specifically in illuminating the role of law in constructing as well as dismantling regimes of slavery and servitude. We will also explore the manner in which legal freedom claims made by disfranchised and subaltern groups have been instrumental in developing our modern notions of citizenship and rights. When faced with racial terror and extra-legal violence by state actors as well as vigilantes, for the period that I'm studying, Reconstruction and its aftermath, the rule of law and concepts such as equality before the law, due process, and legal protections and civil rights take on a whole new meaning. That was the genesis of this workshop, my interest in looking at the intersections between the law and the history of the Black struggle for citizenship. And I'm grateful that our distinguished speakers today agreed to participate in this workshop, though I have to apologize to our visitors from California and Maryland for this very dreary New England spring. Now, before I introduce our speakers today, I would like to thank a few people who have helped put together this workshop. First and foremost, Mary Mahoney, my super efficient Draper research assistant who planned all the logistics for this workshop. I would also like to, definitely deserves a hand. I would also like to thank the history department staff, Jessica Muirhead and Kathy O'Day, who responded promptly to our pleas for help, and the history department as a whole for their support of the Draper series. I would also like to thank Michael Watrous at Academic IT and Junbo Huang, director of UC-SPAN and Yukon TV, who have made the filming of the series possible. You know, we have our own C-SPAN at Yukon. So without further ado, I would like to introduce our speakers in the order that they will speak and hand over the floor to them. Each speaker will strictly have 15 minutes to make their presentation so that we have adequate time for discussion. And otherwise, you will have to answer to Mary, because she's going to signal me when you're done with 15 minutes. Now, this event is being live streamed and recorded, so do make sure that you speak clearly into the microphone. An admonition not just for our seasoned speakers, but also for members of the audience who ask questions. Our first speaker, Ariella Gross, is the John B. and Alice R. Sharp Professor of Law and History at the University of Southern California Gould School of Law. She is the author of What Blood Won't Tell, A History of Race on Trial in America, which has won the J. Willard Hurst Prize for the best book in social legal history from the Law and Society Association, the Lillian Smith Book Award for the best book on the South from the Southern Regional Council, and the American Political Association's Prize for the best book on race, ethnicity, and politics, among others. She is also the author of Double Character, Slavery and Mastery in the Antebellum Southern Courtroom, numerous law review articles and book chapters, and co-author of several history textbooks, including America Past and Present. She received her bachelor's from Harvard University, her JD from Stanford Law, and her PhD in history from Stanford University. She has held several fellowships, and I'm rather envious of all of them, most notably from the Guggenheim Foundation, the American Council of Learned Societies, and the National Endowment in the Humanities. Now, in her talk today, Professor Gross will discuss enslaved people's freedom suits in Cuba, Louisiana, and Virginia, comparing the opportunities for people of color to make claims on legal institutions in 3 different legal regimes. Her talk will illustrate how enslaved people helped to shape the meanings of race in these societies through their claims making. Our next speaker is Timothy Fisher, the 17th Dean and a Professor of Law at the University of Connecticut Law School. Prior to becoming Dean, he was in private sector for 35 years, a partner at a major regional law firm with a long history of public service. His practice and publications have focused on the field of ethics, alternate dispute resolution, commercial transactions, construction law, family wealth disputes, and municipal law. He has also led pro bono engagements in such fields as marriage equality, prison conditions, speedy criminal appeals rights, and strategic relationships of nonprofit organizations. A graduate of Yale University and Columbia Law School, Dean Fisher has been president of the Connecticut Bar Foundation and involved in legal aid and innocence projects. He recently chaired the State Commission on Judicial Compensation and co-chaired the legislature's task force on access to legal counsel in civil matters. He previously served on the Governor's Commission on Judicial Reform, as well as on various commissions of the Connecticut Judicial Branch. Now, his talk is on the large role of indentured servitude in populating British North America's colonies, focusing on the economic, social, and legal conditions that supported it, and at the factors underlying its decline and its legacy. Our next speaker, Kent Newmyer, is also a professor of law and history at the University of Connecticut School of Law, where he has taught since 1997. He specializes in the political, constitutional, and legal history of the early national period and was named a Distinguished Alumni Professor for Excellence in Teaching and Scholarship, the highest faculty honor bestowed by the University of Connecticut. He is the author of numerous books, and I'm just going to read out all their titles. Supreme Court Justice Joseph Story, Statesman of the Old Republic, John Marshall and the Heroic Age of the Supreme Court, the Supreme Court under Marshall and Taney, and most recently, the treason trial of Aaron Burr, Law, Politics, and the Character Wars of the New Nation. Professor Newmyer's books have been reviewed in various history journals and law reviews, as well as in the New York Times, the Washington Post, and the New Republic. He has appeared on C-SPAN's Book Notes and most recently was a commentator in a documentary on the U.S. Supreme Court. His talk will explain how the Supreme Court's decision in the famous 1842 fugitive slave case, Prigg versus Pennsylvania, was a major turning point in antebellum law and history. And I know all my students here from Civil War America would be very interested in this because we have just covered important Supreme Court decisions that led to the legal retreat from Reconstruction. Now, our last, and in this case the cliche is very true, but certainly not the least, is Martha S. Jones, the Society of Black Alumni Presidential Professor and Professor of History at Johns Hopkins University. Before that, she was at the University of Michigan, where she was a founding director of the Michigan Law School program on race, law, and history, and a senior fellow in the Michigan Society of Fellows. Now, Professor Jones holds a PhD in history from Columbia University and a JD from the CUNY School of Law. She has been a public interest litigator in New York City and a Charles H. Revson Fellow on the future of the City of New York. She is the author of All Bound Up Together, The Woman Question in African American Public Culture, 1830 to 1900, and the forthcoming Birthright Citizens, A History of Race and Rights in Antebellum America. She is also co-editor of Toward an Intellectual History of Black Women and has authored many important articles and essays. She's also curated museum exhibitions and has been published in the Washington Post, the Chronicle of Higher Education, CNN, the Detroit Free Press, among other news outlets. Her work has been supported by the American Council of Learned Societies, the National Humanities Center, the National Constitution Center, and the Gilder Lehrman Institute of American History. Professor Jones serves as co-president of the Berkshire Conference of Women Historians and was recently elected to the Organization of American Historians Executive Board. Now, her talk draws from her new book that shows how African American activists radically transformed the terms of citizenship for all Americans. It recovers the story of how they remade national belonging through battles in legislatures, conventions, and courthouses, even though they faced formidable opposition from colonizationists, black laws, and most notoriously from the U.S. Supreme Court Dred Scott decision. Former slaves established their status through local everyday claims, she argues, and their aspirations were realized in the 14th Amendment, again something that we have recently covered in our Civil War class, which was of course passed during Reconstruction, that constitutionalized national birthright citizenship. So we have a treat in store for you, and without, again, further ado, I'm going to ask Ariella to start with her presentation.
I'm going to stand here so that I can work the PowerPoint. Can you hear me with this mic? Okay, let me know in the back if at some point you can't hear me, just let me know. So I'm going to talk today about the second chapter of a book comparing the law of race and slavery in the Americas using 3 jurisdictions, Cuba, Louisiana, and Virginia, from the beginnings of slavery in the 16th and 17th centuries through to the end in the 19th century. The book focuses on enslaved people who became free by making claims on legal institutions, and then the ways that local courts and legislatures regulated the boundaries between slavery and freedom, black and white. Let's see. That works. So here you can see an example of a finding in a freedom suit in a Virginia case. It's a jury finding. We as a jury find the plaintiff free and not enslaved. We do assess damages at 1 penny. You can imagine the value of a life of labor. There were in fact cases where people sued for freedom dues, to be compensated for their unpaid labor, but those are never successful, in fact, in the cases that I look at. But all over the Americas, you can find suits like this, where enslaved people press their claims for freedom before legal institutions and use the openings that are available to them to do that. And in doing so, they help to shape the meanings of race and the operation of slavery really from below through their interactions with local officials and courts and administrative bodies. In this chapter that I'm going to talk to you about today, which is the second chapter of the book, we focus on showing the effects of different legal regimes on the emergence of communities of free people of color. And in particular, we highlight the puzzle of Virginia, in which the possibilities for enslaved people to become free changed quite radically from the 17th to the 18th century. So we come into a literature, a debate that has its own long history, and in particular, a moment in the mid-20th century when a number of great historians focused on the comparison between what Frank Tannenbaum called Anglo-Saxon America and Latin America. And this comparison, as it was formulated by mid-century historians, and which I'm calling the traditional story, did rely heavily on law as one of its sources and emphasized a very stark contrast between the United States and Latin America, between race and slavery in the US and in Latin America, and used in particular the codes that were handed down from the empires, the medieval Spanish code, the Siete Partidas, and the Code Noir, and the opinions of appellate courts. So it's a very top-down history that contrasted harsh Anglo-Saxon slavery that treated slaves as chattel property, and a more benign Latin American slavery that gave enslaved people legal and moral personality, that favored freedom. And the critics of this view, the revisionists, really de-emphasized law. They said that's just what's on the books, but on the ground, if you look at economies and demography, if you look at what life on a sugar plantation was like, it was pretty harsh in places like Cuba and Brazil, and of course most slaves had very little chance to become free, and so they because they were interested in conditions on the ground, really de-emphasized law. My co-author and I, Alejandro de la Fuente, have benefited from several decades now worth of wonderful legal history that really also tries to look at history from the bottom up, but to take law seriously on the ground and look at law from the bottom up, look at ordinary people's interactions with legal institutions, and so we instead argue, looking at law, that law does matter, and the ability to become free matters because the size of the community of free people of color is important to the development of regimes of slavery, but also to the possibility of people of color exercising citizenship, making claims on citizenship. And we also emphasize change over time, that these varied a great deal over time. The chapter that precedes this looks at both the legal and social precedents that colonists brought with them to the New World. In Cuba, the people who came to Havana in the 16th century had already experienced and participated in the enslavement of Africans in the Iberian cities from which they came. They knew about slavery, and they already had in their local ordinances in places like Sevilla examples of ways to create degraded status for people of African ancestry. And when they got to Havana, they hit the ground running, and they very quickly used their legislative power to establish those racial distinctions in the new colony. Louisiana settled later in the early 18th century. Again, the French colonists come with experience in other colonies in the Caribbean of enslaving Africans and of creating racial distinctions, and so they quickly do that as well in Louisiana. And ironically, it's Virginia where the relative lack of legal and social precedent, not that there are none, but the relative lack of precedent made possible an era of in some ways more fluidity. The biggest difference, however, that we highlight in this chapter is that there are quite different legal regimes with regard to manumission, or the right of an owner of a slaveholder to set free the slave. And in Cuba, that right, which is very much the right of the white master, it's a right belonging to the slaveholder to set a slave free, is never restricted by law in the Spanish Empire. But many of these manumissions are in fact very much the product of the enslaved people's own initiatives to purchase themselves. And in particular in Cuba, the practice of coartación, which is a kind of payment by installment for one's own freedom, develops quite early in the Cuban colony, and practices associated with coartación begin as rights, as essentially practices claimed by enslaved people, and they grow into legal rights that are eventually, in the 19th century, actually codified in Spain. And I'll just mention two of these. One is the notion that if one has paid a portion of one's purchase price, so I have a contract with the owner and I have put down a down payment of 20%, then the enslaved person's claim was, I own 20% of myself and therefore 20% of my labor going forward. And if I am being hired out for wages, then one day a week I keep my wages and put that towards my purchase price. The other was what is known as a carrying paper, pedir papel, in which one could actually choose a new owner, somebody who would be willing to pay the remainder of the price and force a sale to another owner who might be a free person of color. And that was another way for free people of color to engender expand freedom to other enslaved people. In Louisiana, which is also civil law, it's also the Roman inheritance, but it's much more restrictive, and you can see Code Noir, the black code, the race idea is built into even the name of the code that was a slave code. There were a few free people of color who were among the very first to arrive in Louisiana, but very restrictive regime around the right to set a slave free. It had to go through the Superior Council. There are very few recorded manumissions, and it's really actually only after the Spanish takeover, effectively in 1769, when you see an explosion of coartation and expansion of the population of free people of color, but that's not the case under the French. In Virginia, by contrast, we see absolutely no limits before 1691. We know that the first Africans arrived on Virginia soil in 1620, and so you have the 17th century, which is a small, the small colony, the small population. There aren't many people of color, but the ones who lived there at a surprising level, surprising at least looking backwards from what we know about Virginia later, of autonomy and ability to become free. We show in local court records, particularly on the eastern shore of Virginia, a significant number of self-purchases. Now the eastern shore is oriented towards the Atlantic, outward. It's somewhat cut off from the rest of Virginia. But there were individuals, some of the best known are Anthony Johnson. He was actually the first person to have a manumission recorded in local court records. His freeing of a slave, he sued white people and white neighbors and won his cases. He owned a significant amount of property. Elizabeth Key, who is also a free woman of color on the eastern shore, she won her case in part based on the testimony of her white godfather, who said that she was a good Christian and that she would go back to England with him if she won the case, but instead she married her lawyer and stayed. And actually, this was 1647 until 67. It wasn't clear what would happen, whether baptism would require setting a slave free. And so the line was more between Christian and heathen than clearly black and white. And after 1667, the legislature makes clear that absolutely even baptized slaves would not become free. The shift in Virginia happens in the 18th century. We see the first limits on manumission in 1691, but the real ban comes in 1723, and a significant downturn in the number of freedom suits, although they do continue. I think that this shift is really symbolized by the fact that when Anthony Johnson, this comparably wealthy free man of color, dies, his estate went back to the Commonwealth of Virginia because he was found to be a Negro, therefore alien. So the idea that a free man of color was an alien rather than a citizen. Far too difficult to explain this shift. What happens in Virginia in this amount of time, well, I can just say many reasons, both political and demographic, and I think we may hear more about the shift from indentured servitude to slavery, but the alignment of reserving slavery for Africans and Africans for slavery really becomes clearer at that particular moment. And by the end of this period, by 1770, we end up with a situation where the populations of free people of color are much smaller in both Virginia and Louisiana than in Cuba, and where in Cuba the communities of free people of color have a level of social and even potentially political power that isn't possible in either Virginia or Louisiana. In particular, the militias, which grow, they're 11% of the militias at this moment. By the 19th century, they get to be almost 40%. You have much more free, you have actual legal intermarriage, whereas in Virginia and Louisiana, you have much weaker communities of color. So that the legal regimes make an important difference, but it's not just what's coming from the metropole. It's not just what's in the Code Noir or the Siete Partidas. It's the way the law is worked out on the ground. It's the kind of practices that develop in Cuba that there isn't room for in Virginia and in Louisiana at that particular time. And the strength and the size of the population of free people of color, which create this group of people who were very challenging to the effort to align race and status, to align white with free and black with enslavement. The size of that community makes an important difference and shapes the possibilities of claiming citizenship going into the Age of Revolution and the 19th century. Thank you.
Well, thank you. It's great to be here. I'm pleased to talk about this topic of indentured servitude, because what makes it interesting is that, on the one hand, it was of tremendous importance in populating the English colonies in North America. Yet, on the other hand, in the words of our dear president, no one ever talks about it. And it's interesting to explore why both of those things are true, why it was hugely important, and yet why it's so much disappeared from everyday awareness and everyday conversation as we think about this country's early colonial history. So, a bit of context. An indentured servant is somebody who voluntarily enters into a contract to work as a servant for usually 7 years in return for having their passage across the Atlantic from England to the colonies paid for by a sponsor. I'll come back to the details on that. But and then that the idea is that at the end of those 7 years, this person is free, is able to go about building a life for themselves. But during those 7 years, their abilities to exercise freedom are significantly curtailed. And we're handing out a copy of a standard indenture to you now. I'll come back to that in a moment. So, a bit of context on the importance. Estimates are that between half and maybe even 2/3 of all English demographic movement to the colonies in North America between Jamestown and the Revolutionary War were indentured servants. Contrast that to a roughly comparable number of African slaves, and then a smaller number of whites who were able to pay their own way without entering into servitude. That's a massive number of people that came over. How did it work? It worked like this. An individual, usually landless, usually a laborer, usually poor, in England especially, soon Scotland, perhaps Northern Ireland as well, or Ireland, wanted to travel, wanted to move to the colonies in North America, seeing the opportunity for a better life. Could not afford passage. Indeed, passage across the Atlantic in the 17th century was on the order of half of the median annual income of an English person. So somebody had to front that money. And as the Virginia Company founded the colony in Jamestown and expanded in Virginia, they also needed labor. And so they needed to come across a way to transport these laborers to the North America and figure out how to pay for that passage and yet recover that cost. And the Virginia Company invented indentured servitude over the course of about a decade as a method of doing that. The concept had not existed before. What had existed before was, of course, the idea of unfree labor. Indeed, in the 17th century, perhaps a majority of the people of the commercially connected world were not free. Serfs, slaves, or bounded servants. And even in England, for example, ever since the Great Plague of the 14th century, there had been poor laws that bound rural, landless people to be forced to contract for a year of services to some master from whom they could not leave during that period of a year. So that concept existed. But the idea of 7 years was new, and here's how it came about. At first, the Virginia Company, during the first years of the Jamestown colony, tried itself advancing the cost to bring the servants over, and then employing them itself to earn enough productivity, especially from tobacco, to pay for that cost. Well, that didn't work well because, number one, the death rate was high, and many of them escaped, and those who escaped and were caught were tortured, and some were shot. But nonetheless, they resisted tremendously working under those conditions, and the Virginia Company did not have the local incentive to try and control them sufficiently. So then after a few years, they attempted a different approach, which was the Virginia Company would advance the cost of the passage and then lease these workers to local plantation owners. The problem there was that the plantation owners had no incentive to continue to pay on that lease once the servant escaped, which again many did, or died. And so you did not have a unity of the risk and the profit opportunity. And so it was around 1619, 1620 that after this trial and error, the Virginia Company invented indentured servitude pretty much out of whole cloth. And the deal was fundamentally simple, that a person would voluntarily enter into this agreement, their cost of passage to the New World would be paid for by the sponsor, Virginia Company at first, but soon other merchants, and in return, they would work for whoever bought their indenture from the sponsor. And they'd work for that. 7 years was the typical period, at the end of which they would basically get severance pay, enough to start off and live on their own. So this approach was economically tremendously successful, because what it did was it aligned the economic interest with the opportunity. That is to say, and I'll give you specifically how it worked. In, say, Liverpool, as the example of the indenture that you've got a copy of there, the worker would come to the docks and say, I want to go to the New World. He, in this case William Higgins, would sign the form, and the merchant would then pay the cost of passage. The indenture would be done in duplicates, two sides, and it would be ripped in half, and one copy would stay with the servant, and one copy would be handed to the ship captain to carry to the New World. Interesting fact, the word indenture comes from the French word for dentures, which is teeth. When you rip it in half, this piece of parchment would leave a unique pattern between the two sides, thereby being able to prove that each one was authentic, because when you put them back together, you were testing the legitimacy of the person's servitude and their terms. You could prove that they were both the same document. And that appearance of teeth, like dentures, is where the word indenture came from. So the servant would get on the ship, possession of the servant and possession of the indenture would be handed over to the ship captain. The ship captain would arrive in Virginia and sell the indenture to a local plantation owner. And in effect, custody over the servant would travel with the document itself. That plantation owner would succeed to the rights of that servant's labor and would pay for them in the form of reimbursing the cost of the indenture. And then the servant would be constrained for those 7 years. Now, the terms of that servitude had some things in common with slavery and some things that were different. But before getting to that, I want to pause and repeat what you've heard about up until now about the conditions in the early years of Virginia. Because in fact, by the time the first Africans arrived, the concept of indentured servitude was in place. The concept of racial slavery was not in place under English law. English law was well developed in terms of establishing means of oppression based on class, and means of oppression based on religion. But the binary concept of you are either white or black as a legal distinction, as you've already heard, was not well developed in Virginia. And so the first Africans were in fact treated as indentured servants, and as you've heard, they had a number of rights and often were treated pretty close, as far as our records show, to many of the English servants. And it was only over time, as the planters realized the tremendous advantage of the involuntary nature of the African's presence, that the process developed over into slavery. And once it did, the legal impositions occurred, and those that you've already heard, plus one of the most crucial ones was in 1662, when Virginia converted the laws of inheritance to say that status, instead of being patrilineal as it was under English law, with regard to Africans in Virginia, became matrilineal. That is to say, if you were fathered by an English settler, that did not give you the rights of an Englishman. You had the rights of your mother. And that, as much as any other profound difference, created the nature of inherited status of slavery in North America. And it appears, although more work should be done on this, it appears that the whole ideology of racism was a response to this economic and legal change. That if you're going to treat people like property instead of human beings, you need some kind of philosophical, ideological basis for doing so. And hence the changes in the way that the Africans were described and their behaviors that were allowed, from being close to the English servants at first to being so profoundly different by the 1660s and 1670s. So indentured servitude worked in the American colonies as it did through much of the world as was developed later because of a confluence of three factors: economic, social, and political. The economic is that the cost of passage is beyond what a laborer voluntarily can advance on their own. So somebody else has to do it. Socially, these people have got to be willing to move to the new place, and the new place has to be interested in having them there as workers. And then politically, those borders have to be open. Now, obviously, that was the case between England and the colonies, where the English encouraged the emigration and Virginia encouraged the immigration. The whole institution operated at a tremendous level, as we've said, especially in the 17th century into the 18th century. But it showed up in New England in a much different character. There were far fewer, of course, slaves brought to New England, but also the English settlers to the New England more often came for religious than purely economic reasons. But indentured servitude nonetheless was discovered in New England, mostly for American Indians. And records indicate, for example, that in Rhode Island, in the 1700s, perhaps a third of the American Indian population of Rhode Island was being held in indentured servitude. That was not a condition entered into voluntarily. It was imposed legally as a consequence of incurring debt to English colonists. So, over the course of the 1700s, indentured servitude as an institution and the size of its demographic movement to the colonies declined. It declined largely because of a shift in the differential between average income and wealth of workers in England compared to the cost of the transatlantic passage. And over time, as it became closer to the Revolution, there were more and more people who could afford to transport themselves. More and more families liquidated their property and were able to pay for the whole family to come over. And then, at the time of the American Revolution, that interrupted a lot of the transatlantic passage between the countries, and I think brought about an ideological change as well, because as the concepts of the American Revolution began to be absorbed, the whole idea of unfree labor became less natural, a far change from what conditions were a century earlier. And you see a little bit of indentured servitude after the American Revolution, but very little, not for 7 years, certainly. And the court cases begin to show some reluctance about the idea of enforced servitude outside the condition of slavery. And so institution largely disappeared from life by the time of the early Republic. So now back to the question of why don't we talk about it so much? And that is, it's actually, I think, a racial issue. Indentured servants were English. And at the end of their term of service, they were free. And they entered the labor force. Many of them became landowners. And odds are, any white person whose ancestors were here, especially in the mid-Atlantic, Virginia, Maryland, in that area, here before 1750, odds are extremely high that you have indentured servants in your ancestry. But you wouldn't know, because it did not carry a multi-generational tag with it in the fashion that slavery does. And thus we don't think about it very much. So I'll close with just a couple of thoughts about the very concept of unfree labor that was at the core of indentured servitude and where it's actually still with us today in a different context. The one thing that makes indentured servitude or any form of bonded labor work is that if you're the employee, if you're the servant, and you breach, that is to say, you say, I'm not going to finish working under this contract that I have with you, I'm going to walk away, I'm going to find a new job. If that were applied to any of us, the worst that could happen is somebody might sue us. That's the worst. Probably nothing. Under indentured servitude, you could be arrested and you could be returned to your master and forced to continue working. Without that physical compulsion, you cannot have this institution. But in fact, we see it under different names yet today. Bail. What bail is that if you're arrested and you don't have enough money, you are held against your will. If you have enough money, you are not held against your will. You also see it with undocumented workers in the United States and foreign workers throughout most of the world. I've seen it myself in extended family in Malaysia, where Indonesian workers would come. The family would keep their passports. Without their passports, they're subject to arrest if they leave the household. And if they displease the household, they could be subject to arrest just by being expelled from the household. That is, in fact, very similar to indentured servitude. So anywhere in the world where you find that somebody can be arrested just for the fact of doing something other than what their employer wants, we still have that process, and we still have that concept. So there's work to be done. Thank you all very much.
I guess I have the podium here. Can you hear me? Okay. Manisha, thank you for asking me. It's an honor to be on a panel with such a distinguished group of people here. I feel, the interdisciplinary theme is, of course, an exciting one. I feel that I'm living an interdisciplinary dream because I'm a historian teaching at the law school. And I tell you, it's been the learning curve is very steep, but I've learned a tremendous amount. What I'm going to talk about today, the case of Prigg versus Pennsylvania, is a matter of fact a result of a collaborative effort with one of my colleagues at the law school, Professor Alexandra Lahab. And I'm going to pitch an article which we've just written, and apparently just as I talk, it might be coming out in the American Journal of Legal History. So if you're really interested, you can take a look at that. My argument is that the case of Prigg versus Pennsylvania was a major turning point in American constitutional and legal history. Let me give you the bare bones of that case and then see if I can unpack it for you. Prigg concerned Article 4, Section 2 of the Constitution, which you people probably know as the Rendition Clause, and it also, at least by implication, involved the Fugitive Slave Act of 1793. What Article 4, Section 2 did was simply to require that fugitives from labor, that was a euphemism, that is to say slaves who escaped slave jurisdictions, and made their way to free states had to be returned to their rightful owner. Article 4, Section 2 did not say how or by what means or what rights, did not address the problem of free black people who happen to be living in free jurisdictions, and neither did the statute of 1793. So that's the constitutional issue. What brought that into focus was a particular case which arose in Pennsylvania, and it concerned Margaret Morgan, who was a young slave woman who lived in the slave jurisdiction in Maryland, who escaped in the 1820s and went to the free state of Pennsylvania and took her children with her. And she lived as a free woman in the free state of Pennsylvania for 5 years. She married a free black and had at least one child in Pennsylvania, which child was, by Pennsylvania law, free. What happened is, what set the case in motion was that the new owner of Margaret Morgan decided that Margaret Morgan should be returned back into slavery, and he commissioned Edward Prigg and 3 other people to go into the free state of Pennsylvania and take Margaret Morgan and her children back, which is what Prigg did. The problem was he did not abide Pennsylvania personal liberty law of 1826, which provided a certain modicum of due process to protect free blacks. He simply took Margaret Morgan and the kids, took them back to the state of Maryland. That was the origin of the suit. Well, you'd think the suit of Prigg versus Pennsylvania would have been about Margaret Morgan, but as it turns out, it was not about Margaret Morgan. It was about the constitutionality of the Pennsylvania Personal Liberty Law of 1826. In other words, it was an arranged case between Pennsylvania and Maryland, who wanted to settle the meaning of the statute of 1793 in Article 4, Section 2. So the case gets to the Supreme Court, and Joseph Story, from the Free State of Massachusetts, anti-slave judge, delivers the opinion. Basically, I'm going to break down the opinion, but the bottom line of the opinion was that he found that the Pennsylvania Personal Liberty Law, which provided this modicum of due process in rendition cases, was an unconstitutional violation of Article 4, Section 2. So what I'm arguing is that this case, if you look at it closely, constituted a major turning point in American law and American politics. In what respect was it transformative? There's kind of 2 parts to my argument here. I mean, the first part is that Story's doctrine of exclusivism, which he used to settle the case, was a radical departure of any established law. What exclusivism said is that certain grants of power to Congress, even by their definition, belong exclusively to the jurisdiction of the federal government. By their nature, he said, these have to be a federal jurisdiction. Well, the problem with that, of course, there was no precedent for it whatsoever. It was simply a kind of made-up position. You know, when you look at it, in other words, the court gets to say what constitutional provision requires the kind of uniformity to give the federal government a monopoly of interpretation. Isn't that, it seems to me that's kind of implied powers on stilts, right? I mean, Marshall's opinion in McCulloch versus Maryland at least was attached to a particular provision, you know, Article 1, Section 8, Clause 18, necessary and proper. Story's thing was, look, he's the judge, is saying, we need uniformity on this, and hey, we have it. And so therefore, anything that Pennsylvania did to interfere with the return of fugitives violated this exclusivist interpretation. What? First of all, if you're just doctrinally speaking, this is a radical departure from what existed. But you know what else it did that made it radical? Is it changed the perception of what the Constitution itself was. You know, Article 4, Section 2 was a part of, I mean, it was presumed to be a part of this general compromise between the free and slave states that made the federal union possible. You know, the 3/5 clause, the Article 1, Section 9 clause in regard to the international slave trade, you're familiar with that. Not much is known about Article 4, Section 2. It was passed the last day of the convention, almost no debate on the clause. So what happens, however, is that this clause was, by its nature, a ticking time bomb. You know why? Because it was not even a compromise. The free states got nothing at all for this clause. What they did get was a constitutional obligation to return people into slavery. I mean, it was a ticking time bomb. What Prigg did, in a sense, was to light the fuse of this time bomb. So, it's hard to argue after Prigg that the Constitution is a Constitution of freedom. And there were many people in this country who, at that time, who believed that the Constitution, because it didn't mention slavery and so on, that it wasn't a document of freedom. But after Prigg, it's very difficult to take that position, not accidentally. The New England Abolition Society resolution of January 1843, this was a Garrisonian thing. The Constitution, Garrison said, is a covenant with death and agreement with hell. And there's certainly a connection between that statement and Prigg. You know, Garrison did something else that makes it radical. In the Liberator, he called for the old cradle of liberty, which was Massachusetts, to adopt a states' rights position. Massachusetts had always been the center of nationalist sentiment. And here is a possibility that Massachusetts might turn states' rights in order to oppose this exclusivist interpretation of story. The interesting thing is that the lawyers who argued this case, the lawyers from Maryland, actually ended up arguing a nationalist position. So, I mean, we have a radical transformation here. It looks like the South is turning to a national interpretation of the Constitution. Massachusetts is adopting a tradition of states' rights. And as a matter of fact, if you look at Taney's concurrence in the Prigg versus Pennsylvania, Taney was, of course, the Chief Justice. I mean, he went along, of course, with the idea that the Pennsylvania law was unconstitutional. He did not like Story's doctrine of exclusivism, however, because what Story did when he handed down this doctrine, he said that the states cannot be compelled to take part in the rendition process. He expected that they would, but they couldn't be compelled to do so. What Taney felt was that they should be compelled to do so. And you know, that's exactly what he said in Dred Scott versus Sanford, or at least that was the implications of it. It's precisely what the Fugitive Slave Law of 1850 said. That is to say, the states were compelled, and the citizens in the states were compelled to be a part of this rendition process. I mean, it was a radical proposition. What was happening here then is that Southern states' slave law is being imposed on the free states, and Southern states are going nationalist. What the South is doing, and what Prigg permits it to do, is to take control of the national government. And as a matter of fact, they did take control of the national government. If you look at the 1840s, 50s, they controlled every branch of the national government. They controlled the Supreme Court, pro-slave, they controlled Congress, they controlled the Senate, they controlled the presidency. I mean, there's this idea that the South waged the Civil War for states' rights. I mean, hey, they controlled the national government. I mean, Dred Scott was a super nationalist opinion, of course. Well, this is not the big story, though. Not the most transformative part of that. What happened as a result of this exclusivist interpretation and its brutal kind of implications was that a group of lawyers in Boston, really, organized themselves into kind of a mobile strike force to defeat the decision in Prigg versus Pennsylvania. And it developed a states' rights-based litigation strategy to oppose the return of fugitive slaves. What you find here is the beginning of what you might call a democratic constitutionalism as a result of Prigg versus Pennsylvania. So it was just the beginning, Prigg was. And here's what went down. If you look at 1842 down to 1860, as the radicals took on and defeated the law and order people, it was a major transformation. In other words, the conservative forces upholding Article 4, Section 2 controlled Massachusetts. They controlled the federal courts, they controlled the state courts. The leading lawyers, the federal district court judge, Benjamin Robin Curtis, all of these people were, and it was all connected to Harvard Law School, by the way, through Joseph's story. What these radical lawyers did, these upstart outliers, really was to defeat this entire legal establishment. So how did they do it? Well, they built on a loophole in Story's opinion, because Story said in the Prigg that the Constitution does not require states to participate. Story expected that they would. What the radical lawyers did was to turn this into an opportunity to develop their own state-based due process law to resist the federal law. So you have a conflict with a federal law on the one hand, state law, state due process law located in state courts, and especially in the right of jury, against the federal citadel of law and order, I guess you might say. Well, here's what happened. So, the radical lawyers are successful in resisting Prigg, and they convinced the state legislature in Massachusetts to pass a law which guarantees the right of trial by jury in this case. Well, so Massachusetts has thrown down the gauntlet. What happened is the South responded by using its authority in Congress to pass another law. And this was, of course, the infamous Fugitive Slave Act of 1850. There's another marvelous recent book on this. But this was brutal. It made very clear that the citizens in the free states are constitutionally obliged to participate in return of fugitive slaves. In other words, Southern state slave law makes its appearance under the guise of national authority into the states. Well, I mean, it was like a back and forth between the local lawyers in Massachusetts and the national legal establishment, you know, including Webster, Clay, the presidents, Fillmore, Pierce, the whole federal establishment. And so there really was a sort of face-off between these two. So what happens with the 1850 law? What happens is the Boston lawyers refine their organization, they consolidate their power, and they develop an incredible body of litigation techniques to defeat the rendition. You know, when fugitive slaves appear, and so what kind of thing? I mean, all sorts of legal actions are called into being. Traditional writs of freedom, like the habeas corpus writ of personal replevin, all of these things are brought to bear on it. But also tort actions, slander actions. You know, there's a whole range of actions that are, and the radical bar commandeered the courts of Massachusetts at every level. And in the 1850s, the courts were awash with litigation jurisdiction cases. And I mean, they simply kind of wore the Southern agents down. It was expensive, the costs of paying for lawyer fees, jail fees, and so on, made it too costly almost because of the delay. But you know, the real thing, and the real decisive thing came when in the what we call forceful rescue cases, because when the fugitives were imprisoned in state jails, the abolitionists organized, you can tell the story here, but they organized forceful rescues. Of course, that was a violation of federal statute. It was a violation of federal statute, by the way, which also guaranteed a trial by jury, which none of the rendition cases did. So, what happened was the radical bar turned the jury trials in the rescue cases into a massive civil education campaign. And their argument was that the jury has the right to rule not only on the facts, but on the law. And of course, the leading authority in that was Benjamin Robin Curtis, who was a circuit judge sitting on circuit. he took the hard line in this, that sure, absolutely, the judge gets to say what the law is, the jury. You know, what happened is that the radical lawyers beat Curtis. And in other words, the radical lawyers convinced the juries to nullify the Fugitive Slave Act. It was jury nullification, in other words. Hey, what you got here is Massachusetts is employing a new technique of nullification. I mean, hey, South Carolina tried it, but it didn't work. And all of a sudden you've got states' rights in Massachusetts using the jury. But you know, it isn't just that. That's not the only thing that happened. Because in the process of doing this, of elevating the jury into a kind of democratic, local democratic voice of the people, the radical lawyers, you know, engaged in a campaign of civic education. It's, I think, unparalleled, really. Maybe Duke can correct me on this, but there's nothing like it in Antebellum history. And major books on the jury, the jury becomes a lyceum topic. And you know, there was never a single conviction during this period. The juries never convicted any of these people who were charged with forceful rescue of the slaves. In other words, they did effectively nullify. But more than that, in the process of doing this, the lawyers educated the people of the Massachusetts to their rights. Just one other thing that brings this thing to fruition. As a result of this, in 1855, I think the most radical body of laws, maybe in antebellum America, regarding due process and civil liberties. 1855 legislation was a culmination of 2 decades of activity on the part of the radical bar. What it did was guarantee a habeas hearing. It guaranteed trial by jury in rendition cases, all the things that the radicals had been working for. It even guaranteed fugitives the right to counsel paid for out of public money. I mean, hey, that's huge. The radicals did one other thing in 1855. This kind of, in a sense, wrapped it up. They passed a law equalizing education in Boston public schools. In other words, they overturned the case of Roberts, Roberts versus City of Boston, 1850 case in which Lemuel Shaw upheld segregated education. The new legislature in 1855, controlled by the radicals, the legislation probably drafted by the radicals, overturned that decision. And Boston public schools were, in a sense, desegregated by legislative action in 1855 on the basis of the Constitution of 1780. It was incredible. A due process victory. I mean, Professor Lahab and I call this a kind of due process moment. Well, in conclusion, a couple of points. First of all, I think that the story of the radical lawyers in Boston, which is the story, by the way, Professor Lahab and I talk about in this article. I mean, that is a story in itself, which is remarkable. I think it's proper to see this. I mean, they brought down a formidable legal establishment. They put a legal foundation under civil rights. They turned the courtroom into civic forums and made the public participant in a public discourse about law. Law became an element of public discourse, thanks to these people. We see it, in a sense, as the forerunner of modern civil rights organizations like, the National Lawyers Guild, Legal Defense Fund of the NAACP. Alexander Tocqueville stole the stuff from Story, said lawyers are always conservative. They should be conservative, right? What the Boston radicals showed is lawyers can be a democratic force working for just law. There's one other point, and I'll kind of wrap it up here. Prigg, in the sweep of history, what he did, it seems to me, was to create a very clear-cut constitution divided between the free and the slave states. They had to take a stand on Prigg versus Pennsylvania, forced them to take a stand. They drew a line in the sand, the free states and the slave states. And Prigg, in a sense, I think stands as a major step, an attempt at least, in the southern domination of the national government, and certainly the national judiciary. What it did also, finally, because it defeated rendition in Massachusetts. I mean, by the way, this is going on in other states too. It's not just, I mean, it's New York, it's Wisconsin, it's Ohio, but Massachusetts was central because Webster was there, Benjamin Loudon Curtis was from Massachusetts, Story was from Massachusetts. This was the big show. What it did was to destroy the trust which the South could have in constitutional government. There's a lot of interesting scholarship that says constitutional government rests on trust. You know, the understanding that in two bargaining, you have to have faith that the other party is keeping their side of the bargain. What the South concluded, from what the radical lawyers did, was that the northern free states could not be trusted. In other words, it was a step in the disintegration of northern-southern relationships that led ultimately to the Civil War. There's just a final kind of crazy point in this. There's a direct line, I think. I mean, it's, hey, I like Joseph's story. He's a friend of mine, you know. But I think there's a direct line between Prigg and Dred Scott versus Sanford. I mean, Tawney was trying to do, in a sense, what Story began to do, which was to nationalize slavery. Now, by giving the constitutional foundation, the Fifth Amendment, that's pretty much what he did. Both cases, Prigg and Dred, are cases of judicial hubris, aren't they? And demonstrate the limitations of law. And also they demonstrate the inseparability really of law. Thank you.
Good afternoon. I want to just begin by saying thank you to Professor Manisha Sinha for convening us under the auspices of the Draper Chair and inviting me to be part of this conversation today. I'm going to conclude us by bringing us up to the era of the Civil War and Reconstruction by, of course, first going backwards a bit, maybe picking up, in a sense, on some of what I heard suggested in Ariella Gross's talk this afternoon about, you know, the problem that manumission begins to generate throughout slave societies in the Americas. This puzzle, who will free people of color be in a world that increasingly, by the end of the 18th century, is as much marked by abolition, by revolution, by the end of slavery, by a long emancipation, as some historians have put it. Who will free people of color be in a post-slavery society? My questions began with those free people of color and a curiosity about how they thought about law. Did they have a kind of legal agency, we might say? Did they have a legal consciousness? How did that evolve? And then what did they do with that? I was perhaps not unlike Professor Newmyer, long intrigued by the case of Dred Scott versus Sanford, but had begun to think that perhaps Dred Scott really had stood in for too long, for too much. That is, a Supreme Court decision that had ruled that no black person in the United States, be they enslaved or free, could be a citizen of the United States, didn't quite seem to capture the entirety of the question for me. And so I began to wonder what the cultural legal story of Dred Scott might be if we looked closer to the ground, if we looked at the ideas and the actions of African Americans themselves, what would we discover about the questions of race and rights that the Supreme Court decision could never tell us? And I was also intrigued, if not at least skeptical, about what my field of legal history had to say about the history of race and citizenship more generally before the Civil War. The wisdom had been that citizenship was really a non-question by and large before the Civil War, and to the degree that the category existed, it was a rather hollow one. And I was at least skeptical enough that I wanted to dig in. I began in the city of Baltimore, Maryland, with the notion that any person who wants to think about African Americans in law needs to get closer to the ground and to find a place. Why Baltimore? Some of you may know Baltimore is one of those cities that exists in the middle ground, as Barbara Fields once put it, a place that toggles between slavery and freedom, both politically, economically, culturally, and otherwise. It is a place in a sense that is in slow motion, an example of that long story of emancipation. The city itself is home to the largest free African American community in the United States in the antebellum decades. Baltimore is also home during this period to some of legal culture's greatest lights of the 19th century. Maybe lights is too generous a term, but Baltimore is home to Chief Justice Roger Taney, who we've heard a bit about today, and it is Taney's hometown just until the eve of the Dred Scott decision. Baltimore is home to William Wirt, the person credited with really giving us a robust version of the Office of the Attorney General of the United States. But Wirt will retire and return to Baltimore. Reverdy Johnson, who makes an appearance in Dred Scott, and even locally, figures like John Latrobe, who will become ultimately president of the American Colonization Society, but is a local lawyer as well. And Hugh Lennox Bond, who we probably know best for his role in the Ku Klux Klan trials of the Reconstruction era, but who is a young practitioner and then criminal court judge in Baltimore. It is an interesting place to study the nitty-gritty of legal culture. I was also thinking about the long narrative of the African American freedom struggle as I began this study. What does it mean to start with a city like Baltimore that today perhaps embodies as much as any city does the injustice, our incapacity, the inequalities of America that are structured around racism? How could I tell a story about the origins of racism that might illuminate some of what our struggle in Baltimore looks like even today? So these are my questions. To answer them, the journey has been one that's taken me to many sorts of places. It has taken me to high courts. Dred Scott is not an uninteresting case to revisit in this context, but is only as interesting as a case like Hughes versus Jackson, which is an 1858 Maryland Court of Appeals case in which Maryland rejects the logics of Dred Scott and deems that free African Americans indeed do have rights that white men are bound to respect. The right to sue and be sued to protect their property and their persons in a court of law. So high courts figure into our story importantly. Conventions of all sorts. Constitutional conventions. In Maryland in 1850, days and pages in the minutes are absorbed with an effort to define the legal status of free African Americans. Are they denizens? Are they aliens? Are they free people? Are they citizens? How do they fit into a state constitutional scheme? I won't give too much away when I tell you Maryland fails miserably, even in 1850, to resolve that question, but it is an example of what a fraught question it is, even before Dred Scott. I look at legislative proceedings, going all the way back to the 1820s in Congress, where over the admission of the state of Missouri, Congress will debate a clause in the new state constitution that proposes to ban the entry of free people of color into Missouri. For Congress, that question turns, at least in an academic sense, on whether or not free people of color are citizens entitled to the privileges and immunities of citizens by the Constitution. I look a great deal at the personal papers of judges and lawyers who are figures in these scenes. And perhaps most importantly, I look at the lives, the ideas, and the activism of free African Americans in Baltimore. I use their newspapers. I use trial court records. I use African American so-called colored convention minutes, all in an effort to understand how free African Americans are, if you will, at the table in this long deliberation over citizenship before the Civil War, and how they use the spaces they have both to teach themselves about law, to develop an acumen and a sophistication, to engage with some of these leading lights of legal culture in the city of Baltimore, and to begin to craft for themselves a strategy, a point of view about who they are with respect to the nation, and that is they come to claim themselves as birthright citizens. So a little bit about what I learned in this study, and the first is about Dred Scott. So is the second, sort of. Dred Scott is decided in 1857, most of you know, and it is a deservedly notorious case for reasons that scholars much more distinguished than I have taught us. But my contribution is to tell you that Dred Scott really is a late and a largely failed volley in a debate over the citizenship status of free African Americans. That is to say, by 1857, by the time the U.S. Supreme Court has before it a case that permits it to rule on the question of black citizenship, this is a debate that has been roiling and ranging across and throughout legal culture, in legislatures, in conventions, and in courts for many decades. Roger Taney is late to this debate, and as I'd be happy to talk about more, he rendered a decision that even his fellow justices on the court do not honor, and Taney, his reflections on just Dred Scott are reflections about disappointment rather than about having resolved the question of black citizenship. I learned a great deal about the relationship that men like Taney, Wirt, Johnson, Latrobe, Bond, all have to free African Americans very close to the ground in Baltimore City. So no longer can we understand these men, if we ever did, as simply operating through the logics of politics or the logics of jurisprudence. My work in the local court archives, recovering their relationships, their legal wranglings with free people of color throughout this period, help us to appreciate the degree to which their jurisprudence, their arguments, their positions were very much informed by what they understood the struggles were on the ground for free people of color in a city like Baltimore. Taney's decision in Dred Scott is no abstract reflection, even as it is a part of his long meditation on free people of color that dates back to the 1820s. Taney is telling us something about what he knows on the ground in Baltimore quite well for the kinds of relationships he has in the local courthouse with free people of color, in addition to his work on the Supreme Court. It's a story in part about the origins of the 14th Amendment, and in particular the 14th Amendment's birthright provision. If frequently we come to the Civil Rights Act of 1866 and then the 14th Amendment's birthright provision as the beginning of a story of African American claims and struggles over citizenship, I hope this work opens the door to your thinking about the degree to which, in fact, this is the pause or the bookend of a first chapter of that story that begins in the 18-teens with the efforts of free African Americans to stave off colonization, efforts to remove them from the nation, in some instance voluntarily, but in a state like Maryland, periodically by way of force. So citizenship for Black Americans is an effort to stave off colonization, and it is also an effort to stave off the effects of Black laws, those everyday kinds of regulations over where one can live or work or how they might worship, how their family might be ordered. All of these everyday regulations of free Black life, the folks I study believe can be defeated ultimately if they are affirmed to be citizens. And it is ultimately for free African Americans, more so than political rights, more so than the rights that we come to associate with civil rights in the Reconstruction era, it is the right to remain. It is the right to occupy place, to be immune to removal, that is the right they seek before the Civil War. It's one we forget about very quickly as we turn to the political rights battles of the Reconstruction period. But here, the people I study reach for citizenship, construct arguments about citizenship, seek out lawyers who will support their claims to citizenship because they are looking to avoid the example that they study carefully, and that is that of Indian removal. And they understand, or they believe themselves to be at risk for the same fate, and they hope that if they make the case for their citizenship, they can resist that end. As I said, for me, this is also a story, finally, about our present. And perhaps when I began it a long time ago, Manisha Sinha edited my very first essay on this, and I'm eternally grateful to you for that, Manisha. You edited it well, too, I will say. That doesn't surprise you all if you know her. I didn't know back in 2007 when we worked on that essay where we would be here as this work would be sort of coming out in its full form. So there are a couple of lessons I want to offer about this study of early African American claims for citizenship that I hope have some pertinence for us today. The first is that American citizenship has always been contested, that there has never been a fixed, sure, absolute rule of law dimension to the question of citizenship. And the story of free African Americans reminds us not only, as we've heard, that the Constitution is silent on this question, but that indeed that the contests around this category and its rights and privileges is endemic to our democracy, and in that sense, what we are experiencing in our own moment is not exceptional, even as it is tragic. It's also been an opportunity to think about the links between the examples and, if you will, the historiographies of free African Americans, of Reconstruction, and of immigration. Because, of course, my story will take us through the early years of Reconstruction, but if we extend it not very far to 1870, we get to the moment of Congress's amendment of the Immigration and Naturalization Act of 1790. And you might recall, good students of U.S. history in the room, that that act included the word white. That is to say, only white people could become naturalized citizens of the United States pursuant to the Act of 1790. And post-Reconstruction, there's a rethinking of this. As African Americans are deemed citizens by way of the 14th Amendment, the question arises, should we not now amend the Naturalization Act such that Black people can become naturalized citizens of the United States? And the consensus is yes, but there is a question about how to do that. And when that happens, one proposal is that the remove the word white, right? Simply remove the word white, and then people of African descent can naturalize. But that's not what happens, and maybe you know why. Because the concern is that if the word white is to be removed from the statute, now not only would people of African descent be eligible for naturalization, but people of Chinese origin also would be eligible for naturalization. And here we see the beginnings of a link between these two stories, and, if you will, a departure, a distance between the case of former slaves, of people of African descent, and people, Chinese immigrants and their children. It will take until the case of Wan Kim Ark at the end of the 1890s until the 14th Amendment will be assuredly extended to cover the children of Chinese immigrants, those permanent aliens in the United States. And so this ultimately, I think, for us is a cautionary tale, isn't it? It's a cautionary tale about the way in which this nation has been capable, again and again, through these 19th century examples of inviting people in, allowing people in, permitting them to establish communities, families, businesses, churches, civic organizations, to fuel the prosperity of this nation and still permit them to exist in a legal limbo. And I hope that birthright citizenship cautions us about our own moment and our own complicity in permitting that sort of circumstance to continue even today. So with that, I'll say thank you very much.
So as I had promised in the beginning of the session that you were in for a treat, and I am sure that you all agree with me. We've had some really rich presentations, especially considering they had just 15 minutes, and we managed to cover so much ground, well, virtually the entire history of the United States and even earlier, right? And going beyond to the Americas, to Cuba. The session is now open for questions. I will moderate the discussion. Just remember, you are being filmed. We have a mic to circulate for questions, and make sure that you speak clearly into the mic, because not only is this being recorded, but it's going to be put up for posterity on YouTube. So you really want to make sure that you are heard well. Well, I didn't mean to deter people from asking questions, if that is what you're thinking, but just make sure that you answer your question clearly and loudly, and that it is recorded and filmed properly. So, questions? Yes.
Yeah, so that was 4 great presentations. I really enjoyed it. I've got a question for Ariella, for Martha, and for Kent, and I can talk to Tim later. So, Ariella, you mentioned the significance of the size of the free Black community, but you didn't, and I can imagine why, but I'd like to invite you to tell us a little bit more about why that's so important in the playing out of the laws. And Martha, I just really want to hear about Justice Taney's relationships with African Americans in Baltimore and in court and so on. And Kent, you threw out this very provocative statement that the actions of these radical Massachusetts lawyers perhaps were the roots of the Southern sense that those darn Northerners aren't going to follow the Constitution, and maybe that's justified. So I'd like you to play that out a little bit, if possible. Thank you.
So Stephanie, thank you for the question and for the opportunity to say a little bit more about it. So I guess I would highlight just a couple of things, because obviously I could talk all evening. But the first would be the kind of what's the virtuous cycle. I guess the fact that free people of color play such an integral role in fighting for the freedom and enabling the freedom of more enslaved people, so that the more people who initially become free, they often play instrumental roles in purchasing their own family members, and sometimes pooling funds for other people to enable other people in the community to become free. They obviously, even just by setting the example of finding lawyers who will take their suits, certain types of lawsuit were almost contagious in certain areas. For example, in Virginia, the claim that one should be free because one was descended from a free Indian woman, when one person was able to get a verdict that her great-grandmother was a free Indian woman, the news of that traveled through both free and enslaved communities, and sometimes literally hundreds, but often dozens of people might win their freedom based on that first suit. And you can find in one county court records the trial papers from another county that had been brought over to show, look, you know, Indian Nan was shown to be free in Charles City County, and here in Prince Edward, you know, I too am descended from her. So there is this kind of contagion of freedom claims that's possible. And then the other aspect, I think, which is certainly, you know, especially evident over time, over generations, right, is that when a community of free people of color reaches a certain oh my God, what's that word for when you get to the right number? A critical mass. When you reach a critical mass, there are some kinds of efforts to contain and restrict that become politically and economically impossible. So Cuban elites wanted to restrict free people of color too. You can find the same, you know, same ideology of racial inferiority, and these people are not fit for freedom. You can find Cuban elites saying that just as well. They certainly try, and to some extent are successful, like in the 1840s, as happens in the U.S. In the 1840s and 1850s, you know, efforts to legislate things like you know, whether it's mobility or ability to enter particular professions, or insolence against white people, or even what free people of color would wear. So all of the ways that what white elites tried to degrade black people and keep them in their place. But they were never any proposals for removal went, or even colonization of the sort that were seriously debated and serious efforts made in the United States, just never got anywhere at all. There was just no hope, because free people of color the community was just too large and actually had, you know, some political and economic power. And so some things just are kind of off the table. Likewise, any kind of restriction on manumission just wasn't on the table. Oh, you guys have them.
Yeah, I have one. So thanks very much for the question that I invited. Thank you for the question. The example I'll give is one that turns on what is, in the Antebellum era, a sort of nascent right to travel. Justice Taney confronts this question in the 1840s in the passenger cases. You'll recall the court is reviewing the constitutionality of port laws in Boston and New York, and trying to determine whether or not the states have the capacity to regulate, in essence, immigration and the ports, or whether that's exclusively the province of Congress. And Taney dissents in the passenger cases, but his dissent is worth reading, and we do read it in part because we associate it with some of the first articulations of what will become a constitutionally guaranteed right to travel between the states. And Tawney will say it's an essence, right? It's one of the fundamentals of democracy that, for example, a citizen can petition their government. And in the United States, that means if you live in a state like Ohio, say, you have to have the right to travel literally, right, through Pennsylvania, for example, Maryland, in order to get to Washington and petition the government. And so quite literally, Tawney is thinking about the relationship between the Constitution's guarantees and how that is connected to a right to literally travel between the states. Well, in the same moment, Tawney at home in Baltimore lives in a jurisdiction where free African Americans travel is highly regulated by what we think of as black laws. And black laws in the case of Maryland, for example, require that free people of color, if they want to leave the state and later return, have to secure a permit from the local court. They appear before a judge, 3 white respectable persons vouch for them in essence, and then the court grants them a permit that then they will show. Otherwise, they are subject to a fine and oftentimes sale into servitude. Well, one of my early and really important archival finds was a travel permit, 2 of them in fact, issued to free people of color in the 1840s. And signed by Roger Tawney, his wife Anne, and his son-in-law Mason Campbell. And so here, Cornelius Thompson works for Tawney. He has collaborated with Tawney, or colluded with Tawney. Bad word today, colluded, right? But he's colluded a little bit with Tawney to buy his own freedom. They've circumvented Maryland law a little bit, which is why I say colluded. So they have a relationship, and Thompson is looking to travel to the spas in Virginia to work in the off season to make money, which is very typical for free men of color in Virginia. He goes to the spa scene, which is exactly where Tawney goes with his family when they vacation. And I use that example to suggest to us the ways in which, as Tawney's thinking through in the passenger cases, when he says, whatever the states can and cannot do, whatever Congress can and cannot do, whatever this court does, one thing is clear. No one can prevent an individual state from preventing free people of color from entering that state, right? So Tawney is both on the ground, right, appreciating, knowing, got his hands in how it is that someone like Cornelius Thompson is navigating black laws and moving to secure work, among other things. At the same time, he's thinking about those questions in constitutional terms. So I hope that's helpful.
Bethany, I think I understand your question was, did the South pay attention to what the radical lawyers in Boston were doing?
Well, my understanding of what you said was that what the radical lawyers were doing in resisting the Fugitive Slave Law, and then this understanding of Article 4, kind of created the roots for the South to say you can't trust those darn Northerners because they're never going to abide by the Constitution.
I think that's exactly right. And I mean, they did pay attention. And the other thing that's kind of remarkable about what the radical lawyers did, I mean, the Fugitive Slave Law of 1850 was supported by not only the Supreme Court in Prigg, but it was supported by both presidents, both houses of Congress, and of course the 1850 law was a brutal law. I mean, it required citizens in free states actually, if called upon, to participate in returning escaped fugitives. In other words, they were the enforcers of a southern state slave law, this 1850 thing. I mean, to demand that citizens of a free state would enforce such a brutal law. But that's what they did. That's what they expected. And when the radical lawyers were able to resist enforcement, and when they couldn't even get a conviction for outright attempts to forcibly rescue fugitives from federal custody, if the juries couldn't convict, and they didn't convict in a single rescue case, the South did take notice, because these radical lawyers were defying not only Southern interest, but the interest of, hey, Daniel Webster, and Justice Benjamin Robin Curtis, both houses of Congress and the President. And the South rightfully would say, well, look, I mean, what good's a Constitution if you can't enforce it in the northern states, even though it's backed by, and also military force, by the way. I mean, federal troops were called in to enforce this law. And so, I mean, it was an act of huge defiance, and the South really did say, well, look, what's the Constitution? It doesn't amount to too much if you can't even enforce it at this level. So, yeah, it made a difference.
And these people are all over the place, right? Benjamin Curtis is part of this sort of nationalist pro-slavery enforcement regime in Boston, but he's a dissenter in Dred Scott. And then later on, he challenges the constitutionality of the Emancipation Proclamation. So a lot like what Martha was saying about Tony, I guess, right? They go from here. Anyway, so more questions here. Yeah? Yes?
Are we doomed to repeat history by not remembering it, particularly listening to the final two speakers that have direct allusions to what's going on today, except the difference seems to be that the federal government now has a Gestapo-like force in ICE, where it didn't have that before, and I wonder if particularly the final two speakers who talked about really what was happening today would care to draw parallels. The Supreme Court perhaps has not weighed in directly on it yet, but are we to see another decision like the Dred Scott decision that is going to come down?
Thank you, Ken. So I think the first thing to say, of course, is that history isn't a blueprint, right? It doesn't really tell us enough of what we need to know in this moment, which is why I use the phrase cautionary tale, right? But one of the things that the Maryland High Court is most concerned about in Hughes versus Jackson in 1858 is not some utopian vision of a interracial democracy. John Carroll LeGrand is a former slaveholder, a colonizationist. He's in many senses, he's much like Tawney in his social and political orientation. But what LeGrand asks is, a version of a law and order question, right? Which is, if we deem every free black person in the United States to be without rights, without the capacity to come into a courtroom to protect their property, their person, their wages, their families, we will in one fell swoop create, in that example, 75,000 outlaws. And we cannot imagine a future for the state of Maryland if we live with amongst us 75,000 outlaws, 75,000 people who are outside the law. So I think that's, for me, the question, right, of where we are. And how we resolve that has to be up to us in some collective sense. We know how that question gets resolved in the 19th century. It gets resolved by way of civil war, right? By a revolution is the only solution for Americans by 1858, we might say. Is that what awaits us? I don't think so. I hope not. But I don't think that we've brought our best thinking to bear. Not only our best legal thinking, right, but our best moral thinking, our best humanitarian thinking to the question of what it means in this moment to create 11 million plus outlaws, right? People who have no recourse in the courthouse, have no redress before the law, this has consequences, Judge LeGrand would say, not only for them, though most dire, in a most dire sense for them, but for every one of us. So I haven't really answered your question, but I'm hoping that Kent will, now that I've given him a kind of great intro.
Well, thank you. Thank you. Appreciate that. Hey, look, I think it's a great question, and I think the parallels between the current, asylum cases and the rendition cases are really pretty amazing, because these are people, the modern thing, and they risk being sent back into maybe even slavery, but certainly dangerous thing where they're more likely to lose their life. I mean, the same thing was happening in the rendition case, and the ICE agents are sort of like comparable to the Southern agents which slave owners sent into Massachusetts to capture their people and send them back. The interesting thing, I found interesting developments, and I'm sort of talking off the top of my head here, but there is a retreat into federalism, into states' rights, by people who are resisting federal law and Supreme Court decisions. This was exactly what happened in the rendition cases. I mean, and I think somebody, maybe it was Martha, who made the point that, one lesson we're learning is that the Supreme Court doesn't have the final answer. There was a lot of law going on outside the court, against the court, in local communities, and this is certainly true, I think, in resisting these current asylum cases. I mean, localities are playing a very vital part, and federal law might not cut it, even no matter what the federal law says. It might not settle matter. So there is a parallel, I'd say. Yeah.
Absolutely, like the federal marshals and the ICE agents and sanctuary cities of today compared to what happened in Boston in the 1850s. There's some striking parallels. But I was just wondering if Dean Fisher would like to weigh in too, since he ended his talk in sort of the contemporary moment. So,
Yeah, this is, of course, as we all know, acting out in real time right now, and the Connecticut judiciary is in a dialogue, both a formal and an informal dialogue with ICE, about the degree to which the federal agents will respect a zone of neutrality in effect around the courthouses so that Connecticut justice can proceed with parties who are either persons who are either parties or witnesses who are not documented. The risk being, of course, that in many of their cases their names are published, that's publicly available to ICE, they're picked up, and once they're in detention, Miranda rights don't apply. They're extremely vulnerable once they are actually in a federal detention facility. And right now, the ICE has said, no, we're not going to formally agree to respect that space. And so the next move is with the state courts. And who knows what creative alternatives might be found in order to allow the wheels of justice to continue, but without giving physical access at a published time to these individuals. There's a room for creative movement, much like among those Boston lawyers of long ago.
Some more questions here? Yeah.
Thank you so much for your panel. I'm wondering if some of you can reflect on the actual logistics of trying to go to court. I'm thinking about the moments now in our contemporary time when I've had to go to court, the documentation, finding the evidence, paying for it, getting witnesses. And I'm wondering, since all of you talked a little bit about the legal consciousness of the enslaved developing, what that may have been like, because I hear a lot of agency on the part of the lawyers, a lot of agency on the part of the justices, but I wondered if you could reflect on what it meant for an enslaved person to actually try to go to court, to find documentation, to find evidence, to get witnesses, to wait on notification for when their case is going to be heard, while they're trying to maybe live in a hostile household once they file suit against their masters, and then what the financial arrangements are, where are they getting the funds from, or lawyers just sort of wandering around trying to get claimants and paying for them, and so those kinds of issues.
Yeah, so that's a wonderful question, and one of the remarkable things actually about studying freedom suits, and that I think is often surprising, certainly to my students, is that some of the freedom suit statutes, including, for example, Virginia's during starting in 1782 was that they not only provided for enslaved people to sue for their freedom, but for them to be able to sue as paupers, meaning that a counsel would be appointed and paid by the court. And so that doesn't take away from the there are still great challenges, I think, for people who are in bondage and not just free to, pick up and go talk to, sorry, I have an appointment with my lawyer, but, not to make light of it, but really people who are constrained, the lengths that people would need to go in order to talk to a lawyer, as you say, all of the things that are involved in pursuing a case. But if someone could get far enough to bring the petition to court, often they didn't have to be represented by counsel beforehand. They could bring a petition directly, but in most cases, it appears that the enslaved plaintiff has probably gotten a lawyer first, and the lawyer helps them bring the petition to court, and then that lawyer is appointed as the counsel. Sometimes, one of the things the Virginia Act also provides for, and you see this in other places and times as well, is to require, if the petition's allowed to go forward, to require the slaveholder to post a bond promising that they won't interfere with the enslaved plaintiff's efforts to pursue the case, to collect testimony, to get depositions, and so on. And they could ask to be bound out during or taken out of the custody of the slaveholder during the time the suit is being pursued. Often you see that regulation may be there because it's honored in the breach, because there are many cases where people are, you find many petitions where the plaintiff says, please keep me from being sold away, keep my master from doing violence to me, because I'm bringing this lawsuit. So obviously there's a lot behind those pages, whether that's a fear or something that's already happened. When all we see is the petition, we don't know, did they bring the petition and then they were sold away, or they were taken and prevented from pursuing it, or is it just that the rest of the suit's been lost? I mean, so often the records are so thin, but it's clear that that's enough of a danger that enslaved people are always bringing that up, and that there are cases that do get all the way where they succeed in being taken out of getting themselves taken out of the custody, hired to someone else, sometimes even being kept in the jail rather than be in their owner's possession. Seems like a safer alternative. And so sometimes you see people who are stay in jail for months while pursuing a freedom suit. So that's just, those are just a few of the dangers that people have to go through. But just on the legal consciousness point, I mean, one of the things that's so remarkable, of the few lawyers that historians have been able to study and see their correspondence or relationship, what we've been able to uncover about their relationship with their enslaved clients, is how much their clients are pushing the litigation. That is, we don't often get a sense that it's the lawyer kind of orchestrating this, what's going on, but in fact that the slave is saying, I've heard that there's, you need to get testimony from this person, and we can find out indirectly sometimes the ways in which the plaintiffs are pushing the lawyers to do certain things, and sometimes how that knowledge of for example, you know, there was a case in another county, is going through these networks. So it is remarkable how efficiently that knowledge seems to be communicated. Another quick example of that is that when the Spanish take over Louisiana, and they arrive in Louisiana with several militias, including a militia of free people of color, and the lawsuits claiming coartación, you know, these freedom suits based on self-purchase. Freedom suits begin almost immediately after the Spanish arrive. So the Spanish law really expands the possibility for these freedom suits. And it's like they learn about the Spanish law so quickly and start bringing those claims. So it's quite remarkable.
I do think at least one thing I would add is not to downplay what a hostile environment a local courthouse can be for enslaved people and even for free people of color. And the evidence is somewhat anecdotal in my work at least, but people of color can expect to be, you know, openly ridiculed, belittled, and otherwise have their dignity assaulted in a courthouse, even as they are afforded the opportunity to bring their case. And so it is not a small matter, I don't think, to enter the courthouse. In Baltimore, in the 18-teens, there is a brief but very spirited moment in which anti-slavery lawyers are still able to operate within the city. They are a conservative lot. They are really not radical abolitionists. They are men who believe slavery should be regulated by a rule of law, right, rather than the arbitrariness of slaveholders. But they are in the city quite openly and developing reputations that mean when enslaved people have cause or opportunity to bring a freedom suit, at least for a short time, they know exactly who to go to, right? There are 3 lawyers who are doing this work openly, notoriously, and that's very important. The last thing I would mention is communities, and in particular church communities. In a city like Baltimore, African American, mostly Black Methodist and Baptist church communities are really essential sites for appreciating how legal knowledge gets developed, harnessed, how it coalesces and gets mobilized, in part because Black churches in the 19th century come into being by way of law. Those folks who organize and incorporate those churches, even as they might not themselves be able to sign their names, develop enough legal acumen, work well with the justice of the peace or a local lawyer. So the churches are rooted and have their origins in legal knowledge and have their own church law, which is another school, if you will, for both slaves and free people of color in a city like Baltimore. And then we see the ways in which legal knowledge sort of emanates out from there, and folks acting in concert by way of their church connections in the local courthouse. So it's important, at least from my work, to think about how community functions in that way, and that legal consciousness is not simply an individual capacity. It's oftentimes a collective capacity that's shared through institutions like churches.
Sorry.
Could I just ask? Go ahead.
Go ahead. We are running out of time. We have one last question, but I'll let you both jump in if you promise to be very brief.
I got about a 30-second thing, but Martha's point about community certainly figures strongly in the success of these radical lawyers, because they coordinated with the Black community, about 2,000 free Blacks on the north slope of Beacon Hill, and they had a Black lawyer, Robert Morris, who was the connecting link. And Morris argued with Charles Sumner in the Roberts case. So we have the first time, I think, of an appearance of a Black lawyer and a white lawyer arguing an important case. But the community support of the radical legal effort was black community was extremely important.
There's a historical reason for your experience and the frustration of so many Americans in the court system. If you don't have enough money to have a lawyer take care of all that for you, courts are very confusing places. And the reason lies in the fact that our legal profession and our court systems, but the duties of lawyers were established by the profession itself, not by our Constitution, in contrast to most Western democracies where the duties of the legal profession were established by the Constitution, the organizing principles of the country. The result is that while in most Western democracies the obligations of lawyers are first and foremost to further the interests of justice, including equal justice, in the United States the forming ideology of the legal profession was to advantage its participants in large part. So this is good news for law schools because it means there's always going to be work for our graduates, but it's rough news for the cause of equal justice for the rest of us.
Great answer. Yeah. So, Jason, yes.
Hi. Hello, is this on? All right.
Yeah.
Thank you all for this fascinating panel. I've learned so much. I wanted to ask a question about reparations and interdisciplinarity. So I'm teaching a course on Japanese Americans during World War II where we talk about internment, and the topic that we're on now at the end of the semester is redress. And in the discussion that we've had, we've been able to track how the political success of bringing redress to be able to execute redress in 1988, the Civil Liberties Act, was brought by a marriage of history and law, and a particular kind of construction of history that abided by three different kinds of rhetorical positions. One that isolated the act of internment as a unique event. Two, that it was a wartime condition, temporally isolated, and that it was something that the U.S. was going to take care of, and not, say, the UN or some other body. And so, in your presentations, I'm also hearing that there's a necessity to think historically about the law, but also that in the pursuit of reparations for African Americans in the United States, that such an accounting is a necessary part of bringing forward a case for reparations, that if it were led just on legal principle alone might have more reduced sort of scope. And so I'm wondering if you can talk about how you see your work as perhaps participating, engaging in a dialogue about what reparations is, or it can be, and how history and law work together in that fashion. So I hope that made sense.
Tim, do you want to lead us off on that? I'm thinking of freedom dues and indentured servitude. African Americans never got their freedom dues, right? But in any case, anyone want to jump into this question? I know that some of the protections of English common law that the United States follows is something that the enslaved and certainly abolitionists, anti-slavery lawyers got together and took advantage of in securing freedom. Question is, do these protections, will they and can they be extended to talk about reparations and redress? I think that's a great question. Martha, you want to tackle that? No one wants to tackle this? I'll say something, but I'm going to let somebody else go first. Ariella.
So I really appreciate the question, as both Martha and I have done work and thinking about slavery and memory and how the history of slavery is used in the law. I certainly agree with you that. And I always think actually of my teacher, Bob Gordon, has a piece called Undoing Historical Injustice. And one of the ways that he frames, it's a comparative piece, so thinking about He doesn't actually use the internment example, but he's looking at sort of reconstructions, first and second in the United States, and then also in Germany and in Japan, and how do we try to use law to undo historical injustices. And the most common way of framing it is what he would call narrow agency. That's often the most successful, right? If you can, there's a bad guy, and if we can sort of excise the bad guy, so, you know, and then maybe give just a very localized sort of reparation for that, for a particular individual wrong that's just can excise it, and then okay. But the more you have a kind of structural explanation for the, you know, then the harder, and the more you see redress in kind of broad structural terms, the harder it is to make the case. I think all of us, right, are trying to do some version of a broader structural history, right, which also connects, right, slavery with freedom, and those aren't disconnected, and that I think is more challenging for a country, for whether anyone trying to do a reckoning, whether it's a small, you know, we've been involved in sort of the universities trying to reckon with their past, but also nations, or as you say, the international community, the United Nations, and for any of us trying to do that, once we get to the structural, it's a greater challenge to the existing system, and so it's not surprising that those claims are seen as threatening. But I do think that it's interesting, you know, some of the ways they have been bubbling up, and I think universities right now are an interesting site for that, and I hope we'll, you know, see 1,000 flowers bloom.
So I also thank you for the question. And the first thing that came to mind, I hesitated because I'd never said it out loud before, but talking about this work with my colleague, Taya Miles, you know, Miles would say that writing history is an act of justice. And I wonder if writing history, critical, right, history isn't a kind of reparations. If we might not want to at least contemplate what it means to do this work, or why we do this work, or what work we want this work to do in the world, if there isn't a piece of that justice that isn't about a reparations in a sense. I'm most influenced by the work of Sherilyn Ifill, who most people know today because she's the head of the NAACP Legal Defense Fund, but Ifill was also a law professor at the University of Maryland and a scholar, and she wrote a book called On the Courthouse Lawn, which was a history that was trying to speak to the fact of contemporary voter suppression in the state of Maryland. And Ifill really went looking for the cause of that, because what she understood from her years as a practitioner was that the litigation, even the vigorous enforcement of what was then a robust Civil Rights Act wasn't really moving the needle, particularly on the eastern shore of Maryland. And what she discovered was that it was the memory of racial violence, it was the memory of lynching in local communities that the folks she worked with spoke about, and that kept them, in a sense, from the polls, even generations after the literal acts themselves. And Ifill thought a lot about reparations in that work, and her view was that there was a style of reparations that really required lawyers to be something other than litigators, because she believed that the reparations only came through sort of the intimate dynamics and processes of reconciliation within local communities to histories, to shared histories, differing but shared histories of racial violence. And that has really stayed with me, and it connects in a sense to what Ariella mentioned, and which is closer to my experience, on a campus like yours or mine, that the scale really matters, right? And that for, I think, Black Americans, part of what has eluded us are those intimate opportunities to, in community, in complex, troubled community, but in community, reconciling our past and our present, right? Is always stayed with me, and maybe history helps us with that, right? Maybe history is part of the fodder for those conversations, but it isn't the answer to those conversations, because it's not a blueprint, right? Because it doesn't really offer us the answer that we need. We only get those by way of those kind of intimate kinds of engagements with one another. That are very hard to do, but I did them in the book, and I recommend it to people who are thinking about this question. So thanks for that.
Wonderful. On that very, very philosophical and deep note, we are going to sort of end the session, and I invite you all to come to the reception outside, and maybe if you haven't had an opportunity to ask a question, or if you'd like to meet our speakers, please do so then. Thank you so much.